So it's really an honor for me to be part of this Congress, especially this session. Big privilege for me, and also honor and responsibility to make this panel smooth and fruitful. So, distinguished guests, esteemed panelists, ladies and gentlemen, it is my great pleasure to welcome you to this panel on constitutional justice in a comparative view, part 2. But if you look at the program, part 1 is after our panel. So, in a matter of fact, we are the first panel of comparative constitutional justice. And of course, we have gathered today to explore the fascinating world of constitutional justice across different legal systems, and I hope to learn from each other some experiences, some perspectives. And as we prepare to discuss constitutional interpretation across different jurisdictions, I have to share something about constitutional courts and about constitutional justice. Constitutional courts, foremost, because I think they are perhaps the only places, the only courts where the most profound philosophical issues, most profound philosophical principles of governance, of democracy, meet the most mundane issues of everyday life. Last month, because why I'm telling you this? Last month, I was talking to a retired judge of Polish Constitutional Tribunal, and this judge told me something interesting. He told me one day judges are constitutional court judges. They are contemplating the eternal nature of human rights and some eternal values of democracy. And next day, they are deciding whether a tax on ice cream is constitutional or not. So he mentioned to me that during particularly complex cases, some judges secretly wish they were instead resolving the apparently simpler question of the meaning of life. So that's the constitutional courts, and that's the constitutional judges. There are people like we are. And anyway, I will try to be a little more serious. The subject of constitutional courts and their role in democratic societies, I think, has perhaps never been more relevant that is today in a world of struggling democracy. And as many of you may know, in Poland, we are currently experiencing a significant debate regarding our constitutional tribunal and the judiciary system in general, and about the potential reforms, about the potential drafts. We are trying to return to the full democracy. It's a hard way for sure, and I think the issue of our constitutional tribunal is one of the most crucial steps back to democracy. And I think it makes our conversation not just academically stimulating, but also practically relevant. And I will be listening with a great attention and interest to all the presentations, all the papers today. And as I can see that this presentation address highly relevant issues that many constitutional courts worldwide are facing today. This is precisely where I see the special value of the sessions like this in comparative constitutional law. We can share some perspectives, share some experiences of other states. And we are fortunate today to have with us some distinguished panelists, distinguished scholars and practitioners who will share their insights from various jurisdictions. And let me briefly introduce our panelists. First, we have Professor Tudorel from Romania, Rector, Professor at the Alexandru Ioan Cuza University, former Minister of Justice and Constitutional Court Justice as well. Next, we have Professor Marieta Safta, also from Romania, a law professor at Titu Maiorescu University, and she will present the joint Romanian paper on ex officio powers of constitutional courts, regulatory prospects for effective constitutional justice. From Poland, we have Professor Anna Rytel-Warzocha from the University of Gdansk, and she will address from breakdown to blueprint, a hybrid model of constitutional review in post-crisis Poland. And then from Colombia, Professor Germán López Daza of Universidad Surcolombiana. He will share his perspectives on transformative constitutionalism in Colombia, the role of the Constitutional Court in shaping social justice. And finally, from Albania, Professor Arta Vorpsi, Professor of Constitutional Law at Tirana University and Chief of Staff of the President of Albanian Supreme Court. And she will speak about constitutional interpretation through uncontrolled judicial activism, how Albanian constitutional courts answers to political clashes through informal constitutional challenges. And before we begin our deep dive in the constitutional justice issues, one more observation I would like to share. They say that the best constitutions, like the best speeches, should be brief and solid. The US Constitution has about 7,500 words, and it's working. It's enough. So I have to remind you a format of our panel, because I know the constitutional law lawyers can give a long speeches. So the format of our panel, which is as follows. Each panelist will have 7 or 8 minutes for the presentation, followed by some comments or remarks from my side. I will use the privilege of this and make some comments. Then our panelists will have 2 or 3 minutes each to brief respond. And after that, I will try to moderate a discussion with some additional questions, I hope, also from the audience. And if we have time, I will try to make it happen. There will be some space for concluding remarks from the speakers. So without further delay, I would like to invite our first speaker, Professor Marieta Safta from Romania, to begin with Romanian presentation. Please, Marieta, the floor is yours.
Thank you so much for introducing us. First of all, I'd say that it's a pleasure for me and for us to be here today and to participate in such timely and fruitful discussions in the framework of the World Law Congress. We chose as a topic for comparative debates in terms of the constitutional justice the ex officio powers of constitutional courts, inspired by a recent ruling of the Romanian Constitutional Court. I was magistrate at the Constitutional Court of Romania, and Professor Tudorel was a judge of the same Constitutional Court. So we were inspired by a recent ruling of the Constitutional Court of Romania annulling the presidential elections and acting ex officio. And that's why we propose this topic, because we think it's an important perspective for comparative approaches. Traditionally, courts are seen as passive actors, intervening only upon request, yet constitutional adjudication increasingly embraced these ex officio powers, allowing courts to act on their own initiative, especially in matters of fundamental rights and electoral integrity. Recent cases, such as Romanian one, I will explain a little bit the ruling of the Romanian Constitutional Court later. This kind of ruling highlights the growing relevance and controversy as well of such powers. So key questions arise. What legitimizes ex officio actions of the constitutional courts? What are its limits? How should it be regulated to balance judicial responsibility and democratic accountability? This recent ruling at the end of the year 2024 have amplified these debates, at least in Europe, where the Venice Commission was also called upon to issue a report on the jurisdiction of the courts in electoral matters. So referring especially to this Romanian experience and legislative and jurisprudential framework, we wish to set some benchmarks for a more in-depth and comparative analysis of ex officio powers of constitutional courts, regulations, situations, limits, and effects. As concerns the regulations or foundation of the legal basis of the ex officio powers, we can find this basis in constitutions or statutory texts. We can find in these foundations in the case law of the courts, of the constitutional courts. Let's remember the first ruling in constitutional review, Marbury versus Madison, where the Supreme Court of United States have expanded these powers as well. European Court of Human Rights, to some extent, when it comes about pilot judgments, maybe acts ex officio. As concerns the Constitutional Court of Romania, the Constitution provides ex officio review only in the case of initiative to amend the Constitution and laws amending the Constitution adopted by the Parliament. Also, the law on the organizing and functioning of the Constitutional Courts allows the Constitutional Court to extend its control to legal provisions in constitutional review, both a priori, preventive review, and a posteriori review. So the law permits Constitutional Court to expand this control to legal provisions inseparable from those challenged by the parties. So jurisprudence of the court shows broader ex officio practice sometimes in terms of extension of the object and, in rare cases, substitution of the object. It is controversial, but the court referred in such decisions to the object of the review based on the real will of the parties. As concerns the elections, so that ruling I mentioned in the beginning of my presentation, the Constitutional Court established its ex officio power based on the interpretation of the general wording of the Constitution. Because the Constitution established that the Constitutional Court shall shall oversee the entire election process for the position of the president. Shall guard the elections for the president's office. And also the Constitutional Court took into account this general ordering of the Constitution and also its role to not only to guard the observance of the elections, but also its constitutional role as a guarantor of the supremacy of the Constitution. And I will read only a short fragment of the decision. The Constitutional Court said, that by exercising its constitutional and democratic review of the electoral process, the court fulfills its duty to ensure the observance of the procedure for the election of the President of Romania, the ultimate objective of which is to restore citizens' confidence in the democratic legitimacy of public authorities, in the legality and fairness of the election, as well as to dispel any suspicion similar to the elements identified in this case. Because in that case, there were identified a lot of misinformations concerning the electoral campaign, the intervention of the artificial intelligence and manipulation of algorithms in favor of one candidate and so on. Thus, the electoral rights of the citizens, the right to vote and the right to be elected, and the foundations of the constitutional order are protected, which are essential premises for maintaining the democratic nature of the Romanian state as a state governed by the rule of law. So it was about effectiveness of the constitutional justice, and as one of the judges of the Constitutional Court said in a recent conference, it was about the deference of the Constitutional Courts in terms of the relation between the Constitutional Court and the citizens. It's about the expectations of the citizens when they approve this Constitution, empowering the court with the to guard the election, to guard the observance of the elections for the president. And now, just in 2 minutes, risk, critics, and institutional challenges. Despite of this utility, ex officio powers are not without controversy because there are risks of judicial overreach, erosion of procedural neutrality, politicization and public distrust, because this ruling as well determined a lot of debates at national level, at the international level as well. So in order to prevent this kind of debates and to have more trust also in constitutional justice, we need legal clarity and codification, procedural transparency, and institutional safeguard. And concluding, I would say that judiciary should not be immutable, active, or passive. It should be strongly committed to securing our rights and limiting governmental power. And when in cases in which the democracy is in danger, the courts have should have the powers and the duty to intervene. So ex officio judicial powers, in our view, when carefully regulated, can serve as a powerful democratic tools to protect democracy. But I would be curious, we are very interested to see how the ex officio powers are regulated in other jurisdictions, and about your opinion concerning this kind of powers. Thank you so much.
Thank you very much. Indeed, very interesting paper. I have even 2 remarks, but I will wait with my remarks and 1 question until all panelists have the chance to present the papers, and then I will back to this issue. Okay, so we are staying in Europe, but moving to Poland. And so I will give the floor to Professor Anna Rytel-Warzocha from University of Gdansk from Poland.
Thank you very much. Thank you very much. It's very nice to speak to you, especially that this part of the world is perfect for what I want to say. I will talk about Poland, but we look for comparative perspectives, and Latin America is a perfect direction, and African countries, because what we see in Poland in recent years, we've got a shift in the model of constitutional justice from a strict centralized model like in Germany or Austria, the Kelsenian model, towards a hybrid model. So what we have now is a combination of a constitutional court as the centralized, specialized institution, and the right of common courts to decide on the unconstitutionality of law and not to apply, the concrete reform. So in Poland, we do not, in Europe, we do not have a lot of examples of such a model. We've got that in Portugal and Greece, but a lot of Latin American countries, this is for you common. So we should take maybe some experiences from you. Before, I will come to that in a moment. So before, in the 90s, our constitution was adopted, and it was based on strictly centralized model. So the courts could not decide not to apply law because in their opinion, in the opinion of the judges, it was unconstitutional. What they had to do was to suspend the procedure and address a question to the Constitutional Court and check for the answer. But in the period 2015-2016, a constitutional crisis started in Poland. So Constitutional Tribunal was the first institution that was subordinated by the ruling majority at that time. And there was a lot of questions concerning the constitutionality of the composition of the Constitutional Court in Poland. It was not regarded as a guardian of the Constitution anymore, both in Poland, but also by the European, for example, institutions like the European Court of Human Rights, which directly stated that what we have now with that composition does not constitute a tribunal established according to the Constitution. So the legitimacy of the Constitutional Court is quite obvious, and it is quite clear. So when such situation started, our judges decided to, because they could not refer to the Constitutional Court, because there was no Constitutional Court functioning, so they started to decide on the constitutionality of law during the process of adjudication, and they decided in many cases not to apply law because they said, okay, that law is unconstitutional, so we will base the judgment directly on the Constitution. And we even had cases when there was a law adopted by the parliament, and there was a decision of the then Constitutional Court, and they said that this is not constitutional court, so we do not have to follow the decision of the court, and we will anyway not apply that law. So this is formally a combination of the constitutional centralized review and dispersed review. Of course, there are some pluses and minuses of this dispersed review. Advantages like faster rights protection, it mitigates rights of centralized authoritarian drift, but also there are some risks like legal fragmentation, institutional conflicts. But now, today, we are one way in Poland after crisis, because we have a democratic government and democratic majority in the parliament, but the president is still from the previous regime. We have presidential elections in 2 weeks, so depending on the results, we will be able to forward to implement the reforms or not. So what do we do now? Because this is the fact that without amending the constitution, we have this dispersed constitutional review already being applied. So we have some proposals from the Senate of the Republic to change the constitution, to write this right of courts into the constitution directly, but also we have to think after making the constitutional court constitutional again, we have to think about how to adjust, how to combine these two forms of review, the centralized and the dispersed, because we do not have any previous examples and experiences. Yes, so this is why we look into your countries where you have that established. So it would be great if you could share your comments on that. Yeah, because we've got a lot of proposals. We look at different countries. So we think about maybe establishing an arbitration body that would decide on the competences, conflicts between the Supreme Court and the Constitutional Court. We think about introduction of procedural filters, so like if we have, for example, 3 conflicting judgments of the Common Court, so maybe the Constitutional Court of the Supreme Court will have to decide and just give the interpretation to make it unified, or the introduction of joint interpretative guidelines of the Constitutional Tribunal and the Supreme Court that would be based on the model of judicial dialogue and help harmonize the constitutional interpretation. So we just look into other states that are more experienced. So just to finish, yes, so the hybrid model is a fact in Poland. The problem is how to make it effective, how to make it work within the democratic state. So we are aware that harmonization demands the integration of precise new procedures, digital infrastructure, institutional dialogue, but what we also think is just to find some examples, good practices abroad. Thank you very much.
Thank you very much. And now I would like to give the floor to Professor Germán López Daza from Colombia about a very topical, I think, because I was thinking about your intervention because we have had some transformation also in this social justice area in Poland. So I'm very interested how you are struggling with the same issue we had 30 years ago and still pending in Poland. So please.
Muchas gracias, profesor, por su presentación. Voy a hacer mi breve exposición en español. Quiero expresar muy brevemente la situación colombiana en materia de control de constitucionalidad ejercida hoy día por la Corte Constitucional Colombiana y el papel protagónico que ha tenido nuestra Corte Constitucional en el sistema de equilibrio de poderes, de check and balance, de limitación del poder del Ejecutivo, del Presidente de la República, y el otro escenario que es el de la protección de derechos fundamentales, incluido derechos de tipo social, y la creación de nuevos derechos que no están explícitamente consagrados en la Constitución Política del 91. Entonces, primero quiero hacer una muy breve introducción del sistema colombiano. Colombia tiene una constitución política que fue creada en 1991 con la creación de varias instituciones nuevas. Creería yo que tal vez una de las que más impacto ha generado en Colombia ha sido la creación de la Corte Constitucional. Anteriormente no teníamos un tribunal constitucional bajo la anterior constitución. Con la nueva del 91 se creó este nuevo tribunal constitucional tomando un poco la experiencia alemana de la Constitución del 49 de Bonn y la experiencia española más reciente de la Constitución de 1978. Digamos que esos fueron nuestros referentes cuando la Asamblea Nacional Constituyente redactó la Constitución y diseñó el nuevo modelo de Estado, donde pasamos de un Estado de Derecho a un Estado social de derecho. Entonces Colombia hoy día está inmerso entre ese esquema de Estado social que en Europa, en varios países como en Alemania lo tiene muy bien diseñado, Y bajo ese esquema, obviamente, colocamos unos elementos propios del constitucionalismo colombiano. El segundo elemento importante que está muy conectado a eso es la creación de una acción especial para proteger derechos fundamentales vía judicial, que en Colombia se denomina la acción de tutela. En España, por ejemplo, es el recurso de amparo o acción de amparo, como se denomina también en México. En Colombia, con sus propias características, es una acción muy popular que ha sido ampliamente utilizada por los colombianos y que le otorga la posibilidad para que cualquier persona, sin distingo ni de nacionalidad ni de raza, pueda acudir a un juez, a cualquier juez, para demandar la protección inmediata de derechos fundamentales, incluso derechos de tipo social, porque ese ha sido el gran aporte de la Corte Constitucional, la protección de derechos de tipo social. Ese es el segundo punto importante, la creación de derechos, la creación de la acción de tutela como mecanismo de protección de derechos fundamentales en Colombia. Y la Corte Constitucional como alta corte. En Colombia tenemos 5 altas cortes, tenemos una Corte Suprema de Justicia, un Consejo de Estado, una Corte Constitucional, un Consejo Superior de la Judicatura, y recientemente se creó una Jurisdicción Especial para la Paz que fue creada específicamente para conocer los temas del conflicto armado que vivimos con las FARC y que dio como lugar la desmovilización de este grupo guerrillero. Estas 5 altas cortes, dentro de estas 5 que tienen igualdad de jerarquía, está la Corte Constitucional, que pertenece a la rama judicial, tiene 2 funciones importantes, una que es la de proteger derechos fundamentales con la revisión de las acciones de tutela que presentan los ciudadanos. La Corte lo revisa en una instancia especial donde selecciona algunas tutelas. Y en segundo lugar tiene otra función muy importante, que es la de conocer las demandas de inconstitucionalidad que pueden presentar cualquier ciudadano en contra de las leyes que son expedidas por el Congreso y que eventualmente podrían estar violando la Constitución del 91. Esas 2 grandes funciones son las que tiene la Corte Constitucional. Muy brevemente me referiré a la primera función, que es la de la protección de derechos fundamentales a través de la revisión de las acciones de tutela. Allí la Corte, del año 92, que empezó su trabajo, ha hecho un desarrollo jurisprudencial impresionante, una primera etapa que va del año 1992 al año 2000, con la fundamentación de unos precedentes jurisprudenciales muy importantes, donde empezó la Corte a crear la base, el sustento y el fundamento filosófico, teórico y constitucional para proteger todos los derechos fundamentales de la Constitución, derechos ligados a los de la primera generación, derechos ligados a las libertades individuales, derechos como la vida, la libertad de expresión, libertad religiosa, etcétera, pero también empezó a proteger derechos de tipo social a través de una acción judicial que inicialmente digamos que no estaba muy explícitamente consagrado en la Constitución, pero a través de la figura de la conexidad empezó a proteger derechos como la salud. Es así como a través de las acciones de tutela la Corte abrió la posibilidad para que a través de una acción judicial protegiera el derecho a la salud, el acceso a medicamentos, el acceso a intervenciones quirúrgicas, etcétera, etcétera, a través de la acción de tutela. Igual con otros derechos sociales como el derecho al trabajo o el derecho a la educación. Por el otro lado está la protección o la defensa mejor de la Constitución de 1991, que ha sido un papel fundamental para lograr la estabilidad y la defensa de la Constitución del 91. ¿Cómo lo ha hecho? A través del conocimiento de las acciones de inconstitucionalidad que presentan los ciudadanos o eventualmente a través del control automático que ejerce sobre ciertas leyes cuando son aprobadas por el Congreso de la República. De esta forma, la Corte ha protegido la Constitución, incluso en los casos especiales de los estados de excepción. El presidente de la República, como en muchas repúblicas, en muchos estados, puede declarar estados de excepción, estado de conmoción interior, estado de guerra, estado de emergencia económica, por ejemplo, y la Corte lo revisa para establecer que no viole la Constitución. En estos escenarios ha defendido y ha declarado inexequibles o inconstitucionales muchas normas expedidas por el presidente que atentan o que violan la Constitución, y lo ha hecho entonces declarando la inexequibilidad de estas normas. En el actual gobierno, el gobierno haya declarado, si no estoy mal, ya es en la segunda ocasión, ha declarado en 2 ocasiones el estado de excepción. El primer estado de excepción, que lo declaró como el 2023 tal vez, la Corte lo declaró inexequible o inconstitucional, es decir, le dijo: presidente, esos decretos que usted expidió no son acordes a la Constitución, declárese inconstitucionales. Y recientemente expidió el presidente otros decretos que al parecer ya hay una ponencia favorable para declararla también inexequible. Entonces, el papel que juega la Corte Constitucional en el sistema de equilibrio de poderes es vital en la democracia colombiana, y yo pienso que es uno de los papeles protagónicos que ha ejercido la Corte Constitucional. Y en el ámbito de los derechos fundamentales ha sido importantísimo el papel jugado por la Corte en materia de protección de derechos. Brevemente, ya para cerrar, yo considero que la Corte Constitucional en Colombia ha jugado un papel muy importante en estos 2 escenarios, tanto en protección de derechos como en defensa de la Constitución. Muchas gracias.
Thank you very much, Professor. And before I pass the mic to Professor Arta, Vorpsi, a short remark from me. Probably my Spanish is just slightly better than your Polish, but I understand something from the speech, and I think it's some kind of confirmation of a special role of constitutional courts today, and especially in the area of developing the fundamental rights. Even in this hard time of transformation, the Constitutional Court played a crucial role in not just guarding the Constitution, but guarding the fundamental social rights. But I will back to this after the Professor Vorpsi intervention. Please, the floor is yours.
Thank you, Andrew. As you already introduced my topic, I will shortly present 3 cases from the Albanian Constitutional Court, focusing on how a constitution could informally be amended by the constitutional jurisprudence. Constitutions are often thought to be protected primarily through formal amendment rules, yet, as we all know, constitutional transformation can occur also informally, through judicial interpretation itself, with profound consequences for democratic stability. The traditional view treats constitutional change as a formal amendment process. However, modern constitutional practice recognizes that informal changes, particularly those through judicial interpretation, can significantly transform constitutional meaning. In fragile democracies, such transformations can endanger the very structure they aim to protect. This presentation highlights how judicial interpretation can informally but profoundly reshape constitutional systems. Drawing on the Albanian experience, 3 case studies demonstrate how the Constitutional Court's interpretations have altered fundamental constitutional principle without formal amendment. The first case, appointment of government members, is a decision from 2021. During this year, a dispute arose when the President of the Republic refused to appoint a cabinet member proposed by the Prime Minister because he, the President, was not convinced of his professionality. The Constitutional Court had to decide on this conflict and, at the end, emphasize there is a need of a collaboration between President, Prime Minister, and Parliament in appointing the cabinet's member, although the Constitution does not foresee for such thing. However, this blurred clear constitutional roles. As a result, it weakened the Prime Minister's exclusive responsibility for government formation, introducing uncertainty into the separation of powers and undermining executive accountability. The most important thing, this decision, it did not bring any solution to the conflict, which should have been the main concern of the Constitutional Court. The second case is the same precedent, but another issue, presidential impeachment, or we can also call it how much political activism is allowed for the president in a parliamentary republic. Shortly after the first decision, the parliament impeached the president for excessive political activism in several times, including the issue of a decree for postponement of the general election day without any prior consultation with political parties. The Constitutional Court reviewed the case, but it did not find any serious constitutional violation, which caused three major constitutional effects. First, it allowed the president's political activism to be tolerated, despite the fact that he should be politically neutral, diluted principles of unity of the people, and undermining the role of a non-governmental head of state in a parliamentary system, allowing him to intervene in executive's decision which contravenes the separation of power. The third case, it's about the refugee agreement between Albania and Italy. The decision is from 2023. During this year, Albania and Italy signed an agreement allowing Italy to manage migrant centers on Albanian territory. The court upheld this, interpreting sovereignty as flexible, allowing foreign jurisdiction over Albanian territory. This introduces a dangerously fluid concept of sovereignty, weakening the constitutional protection of state territory and contradicting prior constitutional interpretation on this concept. To conclude, so the full report is much longer than that, it's more than 12 pages, but I have to stick to 7 minutes in presentation. Across these cases, we observe an unsettling trend. The Constitutional Court's interpretation are informally reshaping fundamental principles such as executive authority, presidential neutrality, and territorial sovereignty. These are not mere clarification. They are, in effect, informal constitutional changes undertaken without democratic legitimacy and without the safeguards of formal amendment procedure. This is today the core of the conflict between democracy and constitutionalism, not only in Albania, but all over Europe. These examples from Albania demonstrate that even without formal amendments, judicial interpretation can subtly but decisively reshape the constitutional order, reminding us the critical need for judicial restraint in preserving constitutional democracy. Thank you.
Thank you very much, Arta. Thank you for the... I would like to firstly thank to all the 4 panelists for keeping the time perfect. So every of you have stick to the time limit. And 2 remarks from my side and 1 question to all of you, because I see some common idea from all your presentations. The first idea is that I think we have heard a lot of statements, examples that justify the title of our session, of our panel. It is really a comparative panel, and a lot of approaches to the national jurisdiction, keeping the examples from other jurisdictions. I think the globalization of our world, I don't know if it's good or bad, but it's influencing our how we see the constitutional law. We try to learn from each other. It's better to, of course, it's better to learn from each other mistakes. But you can give some your examples, your experiences, and take the other one. And the second remark, it's this issue I see in common of all your presentations. I think it's quite topically last, I don't know, 10, 20 years. It's the issue of judicial activism. What Marieta said about the ex officio powers of Constitutional Court is a special form of judicial activism, procedural one. It's not a substantial one, but procedural one. Well, the court should be active, not how to justify the sentence, but why, in which situation, and why should he intervene from the court side. The Anna presentation was about something about the bravery, even the bravery of the ordinary judges in Poland, because Polish constitution is not clear about, it is a centralized constitutional model. It is not clear about the ordinary judges to work as a constitutional review. But in this special situation, in our late years, there was a need to find something. It was not even a self-defending democracy. It was something like the counter-attacking democracy. We found our way to fight back some bad sides of our constitutional system. But it was also something like the judicial activism, for sure. The issue with your constitutional court in Colombia, I think, as far as I understand that, I think it's also the active constitutional court, especially when the people, when the citizens need it in this social area. And Arta, your presentation was literally judicial activism. It's three concrete examples. And my question to all of you, and maybe some experiences from the audience, I was thinking about what are the limits of judicial activism. Of course, we can find judicial activism like something we need, some kind of a line of defense against the politics, because judicial activism is an issue of some tension between constitutional court and parliament. And parliament is a political body. Of course, it's always a political body. And when the court, constitutional court, especially constitutional court, is more active, it is going in the sphere of parliament. So it is not parliament, not even just the parliament, executive power as well. So what are the limits of judicial activism? Because it is not written in any constitution. We have to find the limit ourselves. What do you think about this limit of judicial activism? So I think we can, you can respond in a way we started our presentations, our papers. So Marieta, here's your mic.
Indeed, it's a key question, this question concerning the limits of the judicial activism. Now, supporting the idea of judicial activism, I remember when you made your remarks about a beautiful remark of the former president of the Constitutional Court of Czech Republic in one of the conferences of the constitutional courts, European constitutional courts. He said, in essence, that constitutional courts are not only decorations of the palace of powers, something like this. So they should act in order to perform their role in a democracy. However, the difficulty is to keep this role balanced between activism and deference. A very deferent court is not so useful for a democracy. And also a very activist court raises the questions concerning the limits of the competence of the courts. As concerned the legislation in Romania, and I think it's similar in other states as well, the law on the organization and functioning of the Constitutional Court distinguished between powers of the courts and competence of the courts in exercising these powers. As according to the law, only Constitutional Court is entitled to establish the limits of its competence, and no authority, is not authority, no institution can have the right to challenge this competence. So the limits is somehow in the hands of the judges, and we discussed in the previous panel about the importance of selecting judges to keep this balance. But also I think that we need procedural safeguards. We discuss about procedural activism, and it is very important to have this kind of procedural safeguards in order to establish a more clear limits and not let the competence only in the hands of the judges. Somehow it's a terrible challenge for themselves as well in very complicated situations. So it's the questions raises, your questions raises other questions, I think. Thank you so much.
Yeah, indeed, some questions raises another questions, and I would like to give you an example of this, because you said that the judicial activism is in the hand of the judges, and some judges, some courts, and constitutional courts, of course. So I would like to give you an old question: who will supervise the supervisor? If we look at the Constitutional Court as a highest interpreter of the Constitution, of the highest supervisor of Constitution, who is going to supervise this highest supervisor? It's a circle without the end. Where is the answer? If there is any answer. Okay, so Anna, please.
Thank you. Yes, so this is a very difficult question that you posed. Of course, formally, when we talk, we have a constitution, we have constitutional principle of legalism, division of powers, and so on. But in some situations, it is not effective only to protect these borders of the activism of the judges. In Poland, when judges became very active and they just reinterpreted the constitution and said, okay, before 2015, we agreed that we cannot, decide, review the constitutionality of law during its application. But now we see that, it's not so clear. So the constitution allows for also another interpretation so we can follow. So it was generally accepted in Poland by the doctrine of the constitutional law as well. But still, there's a lot of constitutional professors that say, okay, but this is only for the moment, because you had a very extraordinary situation. So at that moment, it was okay. But if we are again a democratic country, so you should not follow, yes? So this is the discussion that we have. Should it stay? We should decide, because then we have a problem. Who is to say, okay, now we are democratic, yes? So we've got democratic constitutional tribunal. This is also a question of the legitimization of the Constitutional Court that is elected by the parliament. Yes, so, okay. But when it comes to the activism of the Constitutional Court judges, in Poland we also have discussion on the reforms, how to make the Constitutional Court constitutional again. And there's no doubts about some judges that they are unconstitutionally appointed, so they should not be in the Constitutional Court. But we also have some judges that were appointed according to the Constitution by the Parliament, elected by people in free elections. But the plans of the government are to finish this term of office, their term of office, because they acted against the Constitution. So formally it's everything okay, but when you look at this jurisdiction subordinate to the political interests, yes, of the previous ruling party, yes, so then we will have to think about that.
Okay, thank you, Anna. And some short addition to what Anna said. We were discussing the idea in Poland during this constitutional crisis, the idea, the status of emergency doctrine. When there is some crisis, you have a state of emergency. So we are discussing in Poland state of constitutional emergency. And it was justifying extra constitutional measures. It is not contra-constitution, but you can say parallel to the constitution. So you have to find these institutions. You have to find something not contrary to the constitution, but about something is this praeter legem, we can say. So this idea of dispersed constitutional review is something we find justified by the state of constitutional emergency. But if this threat is over, there is a question. What should we do with this dispersed review? Because there is no state of emergency. Should we stay with this dispersed review, or it's not needed anymore? Okay, so Germán, please.
Gracias. En el caso colombiano, indudablemente ha habido un debate muy fuerte en Colombia respecto a si la Corte Constitucional es una corte activista. Muchos sectores de la doctrina, en varios escritos, mucha literatura científica, se han hecho análisis de la jurisprudencia constitucional para examinar hasta qué punto podemos decir que la Corte es activista. O sea, una Corte activista o un juez activista sería aquel que va más allá de ese proceso de interpretación literal de la norma y se convierte en un creador de norma. Digamos que eso podría ser una característica de un juez activista. Evidentemente, si vamos a esa definición, se podría decir, sí, la Corte Constitucional colombiana se podría decir que es una corte activista. ¿Por qué? Ejemplos hay muchísimos. Desde las décadas del 90, la Corte empezó un proceso de reconocimiento y desarrollo de derechos fundamentales de la Constitución y empezó a hacer la creación de varios derechos. Por ejemplo, legalizó el consumo de la dosis personal de estupefacientes a través de una sentencia del año 94. Eso fue una sentencia que causó muchísimo impacto en Colombia. No estábamos acostumbrados a unos jueces activistas. Más adelante la Corte legalizó o posibilitó la eutanasia por vía judicial, porque no había normatividad legal que reglamentara la eutanasia en Colombia. El aborto más adelante lo legalizó en 3 casos en el año 2006. Más adelante, hace poco, hace 2 años, la Corte despenalizó completamente el aborto en Colombia. Le ordenó al Congreso que regulara ese tema, el Congreso no lo ha hecho. Entonces, ¿qué pasa en Colombia? Cuando el Congreso no regula algo, pues la norma que crea la Corte es obligatoria para esos casos. El suicidio asistido, otro caso paradigmático que ha ocurrido en Colombia. La Corte despenalizó el suicidio asistido, le había dado la orden al Congreso que regulara, no lo hizo, entonces la normativa de la Corte es obligatoria. El matrimonio entre parejas del mismo sexo, la adopción de menores por parejas del mismo sexo, es decir, hay un listado larguísimo de ejemplos en donde en Colombia uno puede decir hay un activismo judicial que incluso se ha llegado a tildar como un government of the judges, es decir, un gobierno de los jueces.
Muchas gracias. Thank you for the confirmation that the Colombian Constitutional Court is a corte activista. And thank you for the remarks about the relations with the parliament. I think it's important about this regulation. So the parliament is trying to give some limits. Okay, thank you very much. So Arta, please give your remarks.
Yes, I try to give a short answer for this big question. So how much judicial activism is allowed? I would say that for the Constitutional Court, the judicial activism is allowed as long as it does not alter the meaning of the Constitution provision. So in these three cases that I introduced today, the judicial activism of the Constitutional Court lacks on analyzing what would be the short-term effect and the long-term effect of its decisions. So, for example, in the case of the appointing of a cabinet member of the government, this was not the first time the Constitutional Court dealt with this case, with this matter. So there was, let's say, jurisprudence there. The Constitution is quite clear about balancing the power among the state powers. So giving or shifting the powers among different institutions for the sake of the, let's say, short-term peace among them, this is not the answer.
Okay, thank you very much. But another time, the one question raises another question. Who is going to say that this kind of interpretation is still according to the Constitution correct, of it's over the limit? Still Constitutional Court? Or? Okay. Okay, so if the academics, so maybe it means that we have some time for discussion. So I would like to give the chance to the audience. Maybe you have some questions. Of course, we have a mic, so we can share the mic. Maybe there's some few people, so maybe we start from you.
Sí, voy a hablar en español porque hablo poco inglés. Basando más o menos en lo que, bueno, mi nombre es Luis Collado, primero. Me voy a basar más o menos en lo que ustedes han planteado en varios de los aspectos. Uno tiene que ver con tal vez el extra o el suprapoder del Tribunal Constitucional, de quién supervisa a quién. Y otro es basado fundamentalmente en una tesis que se desarrolló sobre la jurisprudencia, sea constitucional o sea la ordinaria. I could try to speak a little English, but I feel more comfortable speaking in Spanish, basically. La jurisprudencia como una facultad excepcional que tienen los jueces, en el sentido de que se supone, por un lado, en el caso de la jurisprudencia ordinaria, que el legislador es quien tiene la facultad para disponer qué hacer. Y en términos de lo que es el Tribunal Constitucional está el constituyente o la Asamblea Revisora de nuestro país, como en muchos otros lugares también. Y por vía de consecuencia, el rol que se le puede reconocer tanto al Tribunal Constitucional como al Poder Judicial, en un caso hipotético, es un poder limitado que no puede pretender desconocer lo que es la facultad o el poder que tienen las autoridades electivas a quienes el pueblo, dentro del marco de una democracia representativa, participativa, ha determinado que esa es la función de cada uno de los órganos que constituyen los poderes del Estado y también los órganos públicos, constitucionales, dentro de los cuales podríamos establecer, por ejemplo, el Tribunal Constitucional. Dentro del marco de lo que ustedes han establecido, yo he pensado, bueno, pero tenemos un Tribunal Supremo de los Estados Unidos que no tiene un Tribunal Constitucional creado, tiene funciones constitucionales y no constitucionales, y sin embargo ha funcionado, guardando el hecho de si son vitalicios o no los miembros de ese tribunal. No sé si me están entendiendo, si tengo que hablar en inglés, hablo un poquito en inglés. ¿Me entendiendo? Entonces, esa es una inquietud sobre el poder de quién regula a quién y bajo cuáles condiciones. Y el otro sobre el poder activo de un tribunal constitucional que atribuye funciones que posiblemente van mucho más allá de lo que se ha pretendido tanto en la Carta Constitucional como lo que es el hecho de que quienes deciden qué hacer mediante un mecanismo electivo es el pueblo. Y desde el momento en que el Tribunal Constitucional comienza a tomar decisiones que le corresponden, por ejemplo, a la Asamblea Constituyente, al Poder Legislativo, en esa laguna, se está convirtiendo en un legislador negativo que posiblemente esté desbordando las intenciones, las pretensiones del pueblo o del poder de donde nace la soberanía de cada uno de esos órganos. Entonces, yo creo que la idea está clara, ¿no? En cuanto al planteamiento y también las posibles soluciones, en cuanto a los límites que deben tener esos órganos del Estado, para no desbordar lo que es una democracia participativa representativa y donde se reconoce la legitimidad del pueblo como fuente de todos los poderes del Estado. Es la idea de lo que yo creo que puede ser una cosa.
Okay.
Primero yo. ¿Está activo? Buenas tardes. Hacia Pérez. Mi pregunta va realmente cuando el panelista de Colombia exponía sobre lo que es el estado de emergencia de un país. ¿Usted cree que nuestro país, en la situación que está, puede solicitar un estado de emergencia? Y si la cuestión que tiene que ver con la unión de parejas de ambos sexos y la adopción de un niño de parejas de ambos sexos.
Hello, welcome to Dominican Republic. Panelists, is very good conversation for the Constitution. But it's fine. The people say the Constitution and the Foundation's right is unlimited. It's not fine, because the Constitution is the limited the power on the government and the people. What is your opinion on the limit the Constitution for the foundational right? Ahora quiero, para que Colombia también nos lo pueda explicar de una manera. Aquí nosotros pensamos que los derechos fundamentales son ilimitados y la Constitución misma dice que deben ser regulados. Entonces, el Tribunal Constitucional no se puede atribuir una acción que es del Congreso, porque la propia Constitución le dice que los regule. Aquí en nuestro país, los derechos fundamentales inician en el artículo 37 y culminan inclusive con los deberes fundamentales, artículo 75. Entonces, se está cometiendo, como decía el compañero aquí, se está extralimitando el poder constitucional, porque el tribunal, la Suprema Corte del Tribunal Constitucional, donde no existe. En relación a eso, entonces eso está creando una distorsión a nivel global. Me gustaría sus opiniones. Muchas gracias.
Please.
Okay, my name is Rector. I'm a student from Mexico. I would like to make a question, but first I need to make a brief summary of the actual situation in Mexico. The legislative power decided to transform the entire judiciary system in Mexico, which seems to me to be, at first instance, a constitutional crisis. And in Mexico, we do not have a constitutional court. So this amendment to the Constitution, for me at least, at first instance, seems to be contrary to the spirit of the Constitution. So my question is the following. Does a constitutional court or a Supreme Court can analyze or review the constitutionality of a constitutional amendment, even if it is already in the Constitution? And that's it.
Buenas, mi nombre es Ulises Santana y me interesa puntualizar dos cositas solamente. Primero, en México, precisamente, que acaba de referirse el joven, el día 1 de junio habrán elecciones para elegir jueces desde el primer nivel hasta el último nivel. Yo lo veo interesante y muy bueno. Me parece que es el único país de América Latina que la tendrá así. Primero, la pregunta sobre eso. ¿Qué le parece a usted el sistema y qué beneficio aportará a la humanidad y al mexicano en particular? Y otra pregunta. En el programa que hemos visto aparece permanentemente la palabra democracia liberal. Y yo entiendo que la democracia es una sola, en el mundo y para todos los seres humanos, porque es gobierno del pueblo y para el pueblo. Y todos los gobiernos que sean para el pueblo y del pueblo es democracia. Entonces, ¿a dónde nos quieren llevar con esa frase, democracia liberal, o es que solamente habrá democracia en el liberalismo? porque el liberalismo ha matado a muchísima gente en el mundo. Y tenemos un mundo lleno de problemas y de poca paz por muchos liberales que tanto daño han hecho. Por lo tanto, esas dos preguntas quisiera que ustedes de alguna manera me las pudieran explicar.
One last question. Okay. Good afternoon. Thank you very much for your presentations. I'm Jose Casal. I would like to build on his comment related to popular support, let's say, for constitutional courts and constitutional courts decisions. He touched on the fact of certain jurisdictions that elect judges to either Supreme Courts or constitutional courts. I will add to that some institutional arrangements that, for example, foresee or establish referendum for certain regulations related to fundamental rights. So in general, the question is, what's your opinion on having a popular vote or popular say in order to legitimize constitutional court decision, because there's a kind of a overarching question, who controls constitutional courts? So I wonder if that's a good alternative or answer to that. Thank you.
Buenas tardes. Me ha atraído significativamente el término de activismo judicial. Nosotros, en nuestro país, solo reconocemos o hemos conocido activismo judicial en una sola materia, que es en el laboral, y pudieran los demás colegas contradecirme o reafirmarlo. Esto indica que nos dirigimos a un estadio donde el activismo judicial se va a sincronizar en todas las materias. ¿Y qué entienden ustedes en este momento que representa el activismo judicial para el Estado democrático, social y de derecho? Muchas gracias.
If there is, okay, so please take the mic and then. Sure. Oh, there's a mic.
Gracias, David.
Firstly.
Buenos días para los expositores y los colegas presentes. Existe una situación universal con respecto a la ejecución de la sentencia de los tribunales constitucionales. Mi pregunta es, ¿qué posibilidad hay de crear la figura del juez de ejecución de sentencia constitucional?
Buenos días, David Laos, República Dominicana. Yo creo que, como se ha dicho, la pregunta es, no sé si la misma que se hacían Hans Kelsen y Carl Smith, en el sentido de, y en Francia también se discutió el tema del gobierno de los jueces, si los jueces tienen poder real en la actualidad y si ese poder real es para limitar el poder o para ejercerlo contra los gobernantes. Lo digo porque en la exposición de el amigo de Colombia está claro que en cuanto a la ejecución de los derechos civiles, los jueces operan magníficamente bien. Pero ¿qué tal cuando tienen que hacerlo frente a los poderes públicos? Yo creo que esa es la pregunta, ¿verdad? Ese es el fondo. Entonces, en la experiencia que habla la colega de Polonia, se dice que no hay una definición clara de eso o que no han llegado a ese punto. Pero me parece que en Colombia, como ya hay ese activismo judicial, constitucional, en cuanto a derechos civiles, ¿cuál sería el caso frente a los poderes públicos? Gracias.
Okay, if that's the all questions, a lot of questions, a lot of preguntas. I think the preguntas are harder for some of us to answer, but because I see that our session, our panel is bilingual, and some of us are not bilingual. So some of the preguntas could be difficult to answer for some of us, but I hope our panelists will try to do their best and give their final remarks about our discussion. So please.
Thank you so much for your questions and comments. Because it's a final remarks and we need time for all of us, I'll try to be short. Answering the question concerning the amendments of the Constitution, because indeed some reforms, we should take care with the reforms, because some reforms maybe are not positive and maybe they are not intended to enhance, I don't know, the role of the institution, but to shrink it. In Romania is very clear in this regard. The procedure for the amendment of the Constitution is very clear, and the power of the Constitutional Court in this regard is clear as well. Because in Romanian Constitution, there are express limits established by the Constitutions, limits of the amendment of the Constitution, and the Constitutional Court is entitled to verify the initiative of the revision of the Constitution and also the law amending of the Constitution. So, and the decisions of the Constitutional Court are generally binding. So if the Constitutional Court found that the limits of the Constitution, the constitutional amendment were not respected by the political power, the revision of the Constitution is stopped. There are other systems where the Constitution is not so clear, but there are other doctrinal and jurisprudential development in this regard. For example, it's famous, the theory of basic structure of the Constitution. I see that you know about this. And it was established by first time by the Constitutional Court of India on the way of interpretation of the Constitution. In essence, it is about not changing, fundamentally changing the constitutional basis of the states and of democracy. And just a short comment on the activism and deference and the limits. I've seen that sparked a lot of interest indeed. I think that in a state governed by the rule of law, all the institutions should respect the Constitution. So also the Constitutional Court itself is bound by the Constitution. And as my colleague Arta Vorpsi commented before, the limit is here, not to pervert, to change the sense of the Constitution in the juridical interpretation. This is a limit. Thank you.
Thank you. So I would just refer to two questions, one mentioned by you. So when it comes to the constitutional review of constitutional amendment, yes, of course, this is a discussion. We do not question the possibility to have this formal assessment of the procedure, but the substantive, of course, yes. So in Poland, it's not clear, and even in the doctrine, we are divided. We didn't have such a situation that our court had to face such a problem to decide on the constitutional amendment or not. But I know that some of the doctrine says that yes, because the Constitution has some basic fundamental principles and you cannot violate by amendment, even if this is according to the procedure. However, I know that there are different different opinions, like my colleagues, so this is disputable. Yes, so we will see. And the second is about this direct democracy and popular vote to legitimize the decisions of the Constitutional Court. I was a big supporter of direct democracy, but after the experience, Polish experiences with very instrumental use of the instrument of referendum, I think that it poses a lot of danger because unfortunately, even if we in Poland in the Constitution has a very nice, a very good this regulation concerning direct democracy, when you read in theory, in practice, it is easy to use it to manipulate. Yes, so I will not maybe extend, but yes, I would be afraid that it would be just to legitimize something, yes, according to the will of the rulers, unfortunately. Thank you.
Bueno, en el caso colombiano hay algunas precisiones que hacer. Hay alguna pregunta que hizo una colega y el colega dominicano también creo que tiene que ver mucho con el caso colombiano. Lo primero que hay que precisar es que, como todos sabemos, las normas constitucionales son normas amplias, vagas, que requieren una reglamentación o un desarrollo por parte del legislativo, en su mayoría. ¿Qué pasa cuando ese desarrollo no se hace? ¿Y qué pasa cuando esas normas son de derechos fundamentales que no están regulados por el legislativo, ¿no? Allí es donde, en el caso colombiano, ha entrado la Corte a llenar, digamos entre comillas, llenar esos vacíos que tienen las normas amplias, genéricas de la Constitución para aplicarlas a casos particulares. Y es allí donde se vuelve un juez activista en el buen sentido de la palabra, porque llega a proteger derechos fundamentales, a crear derechos para poder, digamos que, materializar uno de los principios básicos de la Constitución, que es la dignidad humana. Todo está basado en la dignidad humana, que es el único derecho absoluto en Colombia. Todos los demás derechos son relativos, el único absoluto es la dignidad. Son relativos porque en alguna medida, cuando hay choques entre dos derechos, pues se utiliza la ponderación. Todos sabemos, un derecho debe ser ante el otro, por eso decimos que son relativos, salvo la dignidad humana. Y la hipótesis que usted menciona es muy viable, muy, digamos, en el caso de los jueces cuando protegen, está perfecto. En Colombia la Corte tiene una muy gran reputación por el papel que ha hecho en estos 33 años de desarrollo de derechos fundamentales, de protección de derechos sociales. Pero ¿qué pasaría con un juez que no fuera así de bueno? O sea, ¿quién lo va a limitar? Un juez que restrinja derechos, un juez que no proteja a los ciudadanos. ¿Quién limita a ese superjuez, no? En el caso colombiano es el Congreso de la República, pero se ha mostrado, tenemos un sistema en donde es un sistema ineficaz, que es el Congreso, que es quien judicializa o investiga a las otras dos ramas del poder público en virtud del principio de check and balance. Entonces, digamos que en Colombia no funciona. Esperemos que no tengamos una Corte Constitucional que empiece a restringir derechos o que favorezca el poder del Ejecutivo sin que lo limite. ¿Sí? Hasta el momento hemos tenido una Corte muy independiente, a pesar de que el presidente en alguna medida interviene en su elección. Eso en cuanto al caso colombiano.
Yes, I mean no disrespect, but I have to answer the colleagues who did the question in English. So, about the constitutional review of constitutional amendments, Albanian Constitutional Court has now recently a new competence to review the constitutional amendments, but explicitly the Constitutional says that only on procedural aspects. But I have to agree with Anna, this is disputable, because our Constitution, as many constitutions in Europe, has some foundations which are inviolable. Although the Albanian Constitution does not foresee any unchangeable or unamendable provision, there is a constitutional jurisprudence in Albania stating that, for example, the Article 3 of the Constitution, let's say, foresees for the basics of our constitutions, which could not be amended with a constitutional amendment. So this is the first question. As for the second one, the direct democracy, I share the same opinion also with Anna, that it is a bit tricky. Theoretically, it's a good choice, a very good choice, but practically, I have to go back some 30 years ago, in 1994, when the first draft of our new constitution was proposed to a referenda, and the citizens of Albania voted against it. Almost the same draft, with very little changes, was approved by the parliament 4 years after this, which I could not say if direct democracy is a mechanism that ensures at its best, let's say the best result of democracy.
Thank you very much. And the final, I know, there's a guy watching me. I know, the time is up. I know the time is up, but give me the final word from me. I know that all your preguntas was not answered. Sorry for that. But I hope your time during this panel was not wasted. I think you consider this really stimulating, all your interventions. So kind request from me, let's give some applause to the panelists. And thank you for the discussion, the preguntas. Thank you very much.